Ladies and gentlemen, will the congregation please rise?
Good evening. I'm tempted to say relax, but probably I can't. But can you all please be seated and relax? So it's really a privilege to see all of you here tonight. My name is Ian Jandrell. I'm a Deputy Vice-Chancellor. And one of the things they allow me to do is to interact very closely with the Faculty of Commerce, Law and Management, and it's my absolute privilege to do that. But my duty tonight is actually very, very simple. It's to obviously welcome all of you who are here in the Senate room of Solomon Mshlangu House, and also all of those who are joining us online. But also to introduce to you the procession that you saw enter the venue. And we recognize the Dean of the Faculty, Professor Jason Cohen. I want to say, and still the head of the School of Law, Professor Engele Schlemmer. We recognize Professor Thabo Legwela, who we will hear from later on, giving the vote of thanks. And of course, our inaugurating professor, Professor Carika Keulder. Now, folk, this is a very special occasion. And for professors, it's that moment to actually profess and stand in front of your friends, your family, your colleagues, your loved ones, your associates, and try to help them understand what it is that professors think about and do. And we're really looking forward to hearing that tonight. The other important thing I said, it's like a rite of passage, but our inaugurating professor is, of course, speaking to friends, every one of us in this venue and online. And we are really looking forward to this opportunity to hear you profess. With no further ado, I'd like to ask the Dean of the Faculty, Professor Jason Cohen, to introduce our inaugurating professor. Jason.
Thank you very much, Deputy Vice-Chancellor, Professor Jandrell, Head of School, Professor Schlemmer. Good evening, friends and colleagues. Professor Keulder and your family, welcome. And so many friends and colleagues from the School of Law and from other universities come along to support. It's wonderful. And what a wonderful occasion to celebrate Carika, celebrate your academic achievements and your elevation to the position of full professor at Wits. A special moment for you, and very much looking forward to your inaugural lecture. But before we get to that, I have the privilege of introducing Professor Keulder. Professor Carika Keulder holds an LLB with distinction, an LLM, and an LLD from the University of Pretoria, as well as a BCom in International Accounting with distinction from the University of Johannesburg. She's a full professor at the University of the Witwatersrand, which of course is the reason we're all here today. And she's also an admitted attorney and notary public. Professor Keulder teaches tax law at both undergraduate and postgraduate levels. She regularly presents her research at national and international conferences and has published extensively in accredited peer-reviewed journals. Her doctoral thesis, An Appraisal of Selected Tax Enforcement Powers of the South African Revenue Service in the South African constitutional context, examines the tension between efficient tax enforcement and the protection of taxpayers' rights. This research forms the foundation of her ongoing work into tax administration and taxpayer rights. She holds a C2 NRF rating from the National Research Foundation and is internationally recognized for her contributions to the field of taxpayer rights. It's my pleasure to invite Professor Keulder to deliver her inaugural lecture on the topic of Between Fiscal Duty and Tax Dispute, the Realities of the Pay Now, Argue Later principle.
Good afternoon, everyone, and thank you so much for sharing this special occasion with me. Those of you who know me well know that I always have a to-do list with things that I want to tick off. And I don't really stop when I've ticked off, I just need to move to the next one. But I decided for tonight to do something different, not to think about the next project that I want to do, but rather to reflect on work that I've already done. And I've chosen the pay nor argue later rule, firstly because I think it is the essence of this tension that I investigate in my research, and then it is my favorite tax topic of all times. And then lastly, I feel that the pay nor argue later rules also signifies, the research I've done signifies important milestones in my life. So as I go through the discussion of the pay nor argue later rule, in between I'm going to stop and just reflect and acknowledge important people and occasions in my life pertaining to the pay nor argue later rule. So yes, let's get started. So as the Dean has already said, my research is about the tension between the enforcement actions of the South African Revenue Service and then, of course, taxpayers' rights. When we look at this tension specifically in relation to the pay nor argue later rule, it comes into play when a taxpayer has received an assessment and he wants to dispute this. We have the fiscal duty of the Revenue Authority saying that they need to ensure effective and efficient collection of taxes. This speaks very much to the collective approach to human rights in taxation. We need to ensure that the taxes are collected because those taxes, in theory, should be used to realize socioeconomic objectives, to make sure we have roads, hospitals, and so forth. So that is the fiscal duty that we have on the one side. On the other side, we deal with the taxpayer who is disputing this assessed tax and his rights to dispute it. What happens? He has the right for his matter to be heard, for an impartial forum to adjudicate this matter. And this speaks very much to the individual approach to human rights in taxation, where we focus on the individual taxpayer. So all jurisdictions have this issue. What do we do when there's an assessed tax that's being disputed? Do we suspend the payment obligation? Do we proceed in collecting, or do we do something in between? And in the South African context, we use what we call the pay now, argue later principle. So tax, the wonderful thing about tax, it says exactly what it is, right? So it means you have to pay now, you have the payment obligation, it's not suspended, and then you can proceed with your dispute process, where you say to the Revenue Authority, I do not agree, and I'm disputing it further. So on its own, the pay nor argue later rule doesn't mean much. We simply know that the payment obligation is not suspended. But what is important to realize is the fact that SART has collection powers. So even though you say, well, I know this obligation is not suspended, but I'm not going to pay, SART can make you pay, or they will find other ways. And this is, for instance, with the third-party appointment notice, where SART can tell your bank, or they give a notice to your bank saying, please pay over the money that you're holding on behalf of the taxpayer. So they're basically cutting out the middleman who is the taxpayer in this transaction, and they take it from your bank account. Of course, what is a problem then with the pay nor argue later rule is that the taxpayer might then not have enough money to continue with the dispute resolution process. And I remember hearing about this pay nor argue later rule the first time in a master's class in 2009, where Advocate Lowe spoke about this. And I was thinking, how can this be? This is ridiculous. How can it be when we have all of these rights in South Africa? How can we have this? And this is kind of what made me start going into my research. So that's why I chose the topic of pay now, argue later. So hearing this at that specific stage in 2009, I was at the law clinic at the University of Pretoria. 2009, I was still a candidate attorney, and then in 2010, I became an admitted attorney, and I was the supervising student attorney at the law clinic. And being at the law clinic and the exposure I got to teaching made me realize that I want to do teaching full time. So of course, there at the law clinic, there's certain things that I've learned that you can never take away. And I'm looking at a few clinic Macy's in the audience, where at the law clinic, we were quite a few clinic Macy's. And there's something about the work ethic that you learn from the law clinic, because you know that there's no one else who's going to do it. You need to fix that print if you need to print that, and you need to take it to court, the documents. So I do acknowledge the work ethic that I learned at the law clinic. And then, of course, I need to acknowledge the director of the law clinic at that stage, Mr. Franciscus Haupt. To say that I have the utmost respect and love for him would be an understatement. I will always value the lessons that I've learned from him, how relaxed and how calm he can be in very stressful situations, which is important because I can get quite stressed, and how much I've learned from him about social justice and access to justice. And it's only now that I worked out my inaugural lecture that I realized that those principles from the law clinic is what made me go into taxpayers' rights. And a lot of my focus is on access to courts. So I think what I've realized with my time at the law clinic is you can maybe take the Macy out of the clinic, but the clinic is never out of the Macy. It's always there, part of you, and once you've been at the law clinic. So of course, as I said, I decided then, or I wanted to go into academia, and I think quite a few of you can relate, where you love teaching, you go into academia, and then you get to this realization that you actually have to do research as well. So for me, I had this drive about how can this pay no argue later rule, how can this be? But it's not as easy when you start out how to do research. And I need to acknowledge the people that were really instrumental in assisting me and kind of saying, okay, Carika, we know you need a recipe. Here's the recipe. This is what should be an introduction. This is how you should write a case note. So there I want to specifically acknowledge my friend, she's professor at the University of Durham, Camilla Pickles, who read all my work, everything in my doctorate, even though she is not a tax person. I want to acknowledge Professor Tabula Khwaila. I still remember an email I sent him at one stage to say, can you save me from myself? I don't know how to write. And he helped me. And later I remember going to Citibank asking you, can you please be my supervisor for my doctorate? And then, that was the beginning. And then, of course, I want to acknowledge someone that was in the department when I went to mercantile law, and that is Professor Monre Botha. He was my departmental head, and he led by example, motivating me. I think that was a major turning point for me in my research career, to just really love doing my research. Okay, so now turning back to the pay no argue later rule and asking, how can it be? How can we have such a rule in South Africa? So I wasn't the first person ever to think about that this could be an issue. We have the case, it's a 2000 Constitutional Court case of Metcash trading. And my first article that was ever published focused very much on Metcash trading. And I had the opportunity to revisit it recently for Marius and Roxane's book on landmark Constitutional Court judgments, where I looked at Metcash trading again. So in Metcash trading, the taxpayer argued that their right to access to courts has been infringed and it's unconstitutional. It went all the way to the Constitutional Court. And what is important, what the Constitutional Court said in this regard is, the pay no argue later rule has two objectives. The first one is, we are not delaying the payment obligation simply because a taxpayer is disputing it, but then also we will make the necessary refunds later with interest. And I always feel when I look at the second component of what the court said in Metcash trading, it feels a little bit like when you started a new job and they say to you, if you don't have all these documents completed by the 5th of a month, you're not going to get paid end of this month, but next month you'll get double. And saying that we will refund the taxpayer with interest later on when the dispute has been finalized has the same impact, because delaying using that money could have a detrimental impact on a taxpayer. So the court said these are the two things that the pay no argue later rule does. It is not concerned with access to courts. It does not oust the jurisdiction of the courts. And they provided instances to say, you can see, along the line, there are other opportunities for judicial intervention. The first one is the tax court. So the tax court, those of you who are in tax would know that there's been a few developments where the courts have looked at what is this tax court, what kind of creature is it? And the tax court is not a court of law. It's been found to be a court of review or a court of record if we look at the Poulter matter. But of course, the right to access to courts is not just simply purely about a court. It could be a tribunal. So the fact that there's an impartial person hearing the matter would be sufficient to say that there is access to courts. It's delayed, it's only later, but there's access to courts. And then the second instance that the court identified of judicial intervention is, of course, the inherent review powers of the High Court. So again, there's been quite a lot of developments. Since Metcash Trading, we've had the Tax Administration Act that came into operation, which I'm very thankful for because it gives me quite a lot of scope for research, where we specifically have Section 105 of the Tax Administration Act, which now provides that you cannot just simply directly go to the High Court, even if it's for a review. So what we've seen in all those cases that has recently been heard is that you would need to get a directive first from the High Court saying that it's appropriate or that it's good cause for it to go directly to the High Court. So this means we do not have the inherent review powers that the court spoke about in Metcash Trading. It is now suspended until the High Court directs otherwise specifically. So in relation to opportunities for judicial intervention, Professor Olivier made a really good point in this regard. She was saying the argument is never that the taxpayer will never have access to courts. It's about at the moment when the pay now, argue later rule is invoked. There hasn't been an opportunity for the taxpayer to state his case, to show why he is disputing this specific instance. Another important aspect from Metcash Trading is the court very clearly indicated that we are dealing with VAT. If you read Metcash Trading, they give a really good introduction and explanation of how VAT works. So then, of course, the question arises, if the court found in Metcash Trading that the pay now, argue later rule is constitutional for VAT, would a court reach the same conclusion if it's for income tax? And of course, like all good lawyers, we all say it depends. So Dr. Barry Kroom and Professor van Zyl, Professor van Zyl, you've indicated it wouldn't make a difference. But then Professor Williams, and I almost think Tabo also thinks it would make a difference, right? Whether it's VAT or income tax. So my argument on this is always, it really depends. I think it is important that the court did provide the context and made very sure that we know they're dealing with VAT. But then the distinguishing features the court gave in relation to VAT doesn't really make sense. So in Metcash Trading, the court indicated that the VAT liability is triggered continuously. So as soon as the triggering event occurs, there's a tax liability. So when there's a supply of goods or services in the course of furtherance of an enterprise. And the court said, unlike income tax, where the tax debt only arises at the point of assessment. Of course, now, looking at recent case law, for instance, Henke, we know that assessment is only when we quantify. It is not the point when we establish the tax liability. But it doesn't really matter that much for Metcash Trading's purposes, because it doesn't make sense. Why does it matter when the liability arises to determine whether or not taxpayer, when he has received the assessment, whether that payment obligation can be suspended? The second distinguishing feature the court gave in relation to that is to say, and I think that's where Prof. Lagwala's argument why there would be different treatment comes in, is that for VAT, the vendor is actually an involuntary tax collector because they are collecting on behalf of the consumer. They keep the 15% and then they need to set it off against their input tax. But importantly, it doesn't mean that there's a trust relationship between the vendor and the revenue authority. It is still a debtor creditor. And because it deals with set-off, similar to income tax, where we need to determine what is your gross income and what can you deduct, I don't really see how these distinguishing features really addresses why in the one instance we would have access to courts and in the other one not. So the reasons in Metcash trading why they held the right to access to courts has not been infringed is, in my opinion, not convincing at all. But then, of course, in Metcash trading, initially, the taxpayer also had an argument dealing with Section 25(1) of the Constitution. So Section 25(1) deals with the right to not be arbitrarily deprived of property. And most commentators, me including, were just simply like, they were right to abandon this and not proceed with this line of argument. And then, of course, in 2017, we had the Davis Tax Committee, who in their tax administration report, very vaguely and not giving a lot of explanation, indicated that the pay no argue later rule infringes on Section 25(1) of the Constitution. And of course, this made me think, were we wrong? Did we miss this? Is this a valuable avenue for taxpayers to pursue in relation to the pay no argue later rule? Sorry, I just need a second. So, of course, those of you who know me well would know I'm not a property law scholar. And I think it is important to know what you're good at and what you're not. So I just want to say already now, I had help. I got Professor Richard Brits to assist me, and we wrote an article about this to really see this thing that the Davis Tax Committee say, is there any merit to it or not? So at this moment, I just want to stand still and just reflect on the fact that I've had many co-authors in my career. As I said, Richard Brits. I mean, I even was fortunate enough to write a chapter with the Taxpayer Advocate of America at one stage. So I've had numerous co-authors, and here I want to especially acknowledge two of my favorite co-authors, and I feel like it shouldn't be as much fun as I have when I write with you, Professor Fanny van Zyl and Professor Thabo Legwala. And I know for none of you, tax admin is really your field, but I do appreciate all the tax admin articles we've written together, and I really hope that we can continue writing together if you all just stick to your deadlines. Sorry, I had to get that in. So Richard and I looked at the pay no argue later rule, and can it be said that it infringes on Section 25(1) of the Constitution? We were comfortable to dispose with it is property because the taxpayer's money, it has patrimonial value, and it would form part of that taxpayer's estate if that taxpayer is liquidated or sequestrated. So these principles we get from case law, but the property law scholars would know which cases, of course. Then the second one, the deprivation, that says there to know if it's a deprivation of property is whether it's legally relevant impact that it has on the taxpayer. And here we looked at the pay no argue later rule and compared it to when we deal with a normal enforceable debt that it becomes enforceable due to a judgment. That is not what we have with the pay no argue later rule. There's no judgment. All that we have is the assessment by the South African Revenue Authority. So we were comfortable to find that it is a deprivation of property. Then, of course, it's the trickier part, because in order for it to infringe on Section 25(1), it needs to be an arbitrary deprivation. And for that, you look at two things. It could either be that it's procedurally unfair or substantively unfair. And here, I would have loved to have Richard just explain these a bit better, because it is very much property law, but I'm going to try my best to apply it to the tax context. So for procedural fairness, it is not just simply for property law purposes looking at that moment in time. It is about looking at the entire process. What happens afterwards? Is there procedural safeguards in place in this specific instance? So in this instance, we can see that a taxpayer does have, and this is kind of, I kept it a little bit from you, that a taxpayer can request a suspension. So there is an option, and we'll talk about it in the next slide a little bit more. So there is an option where the taxpayer can request a suspension. And in this suspension request, the taxpayer would state his case. And there's certain things, and we'll talk about it in the next slide or so. that the taxpayer would need to say. And then, of course, when you get to the dispute resolution process, the taxpayer is able to state its case. So for property law purposes and looking at procedural fairness, the penal argulator rule we found to be fair. Then moving to substantive fairness. This deals with what is the reason. There needs to be a good reason why we have this rule. And it is an ends-means analysis. So the way it works is there's a spectrum. We can start either with rationality, or it could go all the way to proportionality. So rationality, in our view, that only rationality would have been required when we do this constitutional analysis of the penal argulator rule. This is simply because the South African Revenue Service is not able to choose its creditors. It's not like any other credit provider saying, okay, you do not meet the affordability assessment, we don't want you as a creditor in this instance. So it is important that they take their victims as they find them. It's the taxpayers. So therefore we felt that it is rationality that is required, and there it's important that there is the option for suspension. If the suspension request is rejected by the South African Revenue Authority, the taxpayer can take that decision on review. And then, of course, what I've mentioned a little bit earlier is if the matter is found in favor of the taxpayer, there's reimbursement with interest, which I don't think is really that amazing as such. We felt that it's not proportionality. But if we were wrong and proportionality is required, clearly it would be harder to prove that the penal argulator rule is substantively fair still. But because there's a clear link between the taxpayer, the property, the money, and the debt, it would meet this proportionality requirement. And of course, the deprivation will only be temporary if the taxpayer was right in disputing this specific assessment. So that is kind of where the Medcash trading, what that brought to the table for penal argulator, and then, of course, instigated by the comments of the Davis Tax Committee. But then I think it is important to also recognize that since Medcash trading, there has been positive developments in relation to the penal argulator rule. So again, here at this moment, I'm going to stop a little bit talking about all the academic things and talk about positive developments in my life. So in 2019, I had to make the decision whether to stay at the University of Pretoria or come to Wits. And I mean, I had to leave amazing colleagues behind at the University of Pretoria. But now, 6 years later, I know they hire a shuttle service and they come if I need them to be here. So thank you so much, colleagues, my old colleagues, for being here tonight. But it was a positive development moving to Wits. I will always remember when I came for my interview, I presented on these developments. I don't know, Judith, where are you? You were in my interview. And you know, Judith was that person that you just need, and she should always be in interviews. She's just so friendly, and you're like, yes, okay, I don't know if she gets what I'm saying, but she looks positive. So I remember it was really intimidating. I started at Wits. I was here for about 2 months, and then we had COVID. And I mean, I've just moved from Pretoria to Joburg. So it was a little bit of a getting used to be in Joburg and not really knowing your colleagues. But I must say, especially when I chaired the research committee, it was an amazing experience just to get to know all of my colleagues. And just, if I think about the 6 years that I've been at Wits already, and I think about how much the conversations that I've had with my colleagues. And I mean, I can always phone and be like, I don't know much about DLICT and I'm scared I'm going to reveal how little I know, but can I ask you this question? So thank you all for always having your doors open. So the School of Law, I want to acknowledge you as a very positive development in my career. Then, of course, there's also not just the School of Law, people in the faculty. I think about the COLT team, how much they have inspired me to be a better teacher and how much I've changed the way that I teach because of them. Also, I saw the Deputy Dean of Research was here. I need to acknowledge how much that specific committee has also assisted in my research in this specific instance. And then, of course, I want to also thank the MCAT colleagues who came specifically to support me today. I really appreciate you being here for me. Okay, so that was the positive developments in relation to my career, and if we go back to what has happened with the pay and argue later rule. So as I revealed a little bit in the previous slide, a taxpayer can request a suspension. But then at the stage of made cash trading, it wasn't clear what the Revenue Authority would consider. So it was kind of an unfettered discretion. Then after made cash trading, SARS released a media release to say, we will look at the following things. But I mean, it's never great when it's a media release. And then we saw that going into legislation. And there has been some changes, and this is currently what we have. What are the factors? So if you are a taxpayer, so this is not just simply academic value, it is real practical value for you. If you are a taxpayer and you receive an assessment and you want to dispute it, you will know that your payment obligation is not suspended. You need to request a suspension, and you can do that on e-filing. But these are the factors that they will take into consideration. So these are the things that a taxpayer would need to address in that specific request. I'm not going to go through all of them. There's just two specific ones that I wanted to touch on. The first one deals, it's C, where the fraud is prima facie involved in the origin of the dispute. So prima facie is simply looking at it on first sight, is there fraud or not? And I do have a problem with this being a factor that the Revenue Authority considers, because it hasn't been proven that there's fraud. The South African Revenue Service is making a negative inference just because it seems like there is fraud. In other instances, if we think about criminal law and its bail proceedings where there's alleged criminal conduct, it's a judge making that decision. It's not like we have with the pay and argue later rule, where SARS kind of becomes the judge and the jury in this specific instance. If we then look at D, it's whether the payment will result in irreparable hardship to the taxpayer. Before, the focus was, and it said very clearly, irreparable financial hardship. And then the financial part was taken away. And I do think it is important to realize that if you have to pay taxes that were not due, it will not only have financial impact on you, it will have emotional impact. But I'm not really sure how the Revenue Authority would be able to assess whether this impact will be irreparable or not. But I think what's more concerning about this specific factor is it doesn't stop there. It's not just looking at what will happen to the taxpayer. It's weighed up against the interest of the South African Revenue Service. So again, they kind of need to decide, are they making their interest count more than yours, or how do they weigh this? So the factors are not above reproach. It is subject to criticism. But I want to acknowledge that having it written in law is a positive development. It's not unfettered anymore, and it makes it possible for taxpayers to know what exactly they should aver. And if SARS does not take into consideration these relevant factors, then of course that is a ground for review in that specific instance. So there's also other positive developments, and this is what I refer to as the grace period. So there was at some stage uncertainty. What will happen if you get the assessment, you decide to dispute it, and now you request the suspension? Can SARS proceed with collecting in the interim? And now the positive development is we have very clearly, it says, SARS needs to wait 10 business days. Only after 10 business days, after they've informed the taxpayer that we are not suspending it, only then would the Revenue Authority be able to proceed with collection actions. So I remember when this came into operation, I thought, okay, that's great for certainty. Now we know how to deal with that. But of course, as soon as you have something that can only start after a few days, that could also potentially provide the incentive for the Revenue Authority to reach a quick decision. Of course, then a taxpayer could take it on review, but that has financial implications for the taxpayer. And of course, your payment obligation is not suspended while you take it on review. So you are kind of, at, 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 those specific instances. So then, of course, as I said in the beginning, this is something that all jurisdictions need to grapple with. We are not unique in South Africa. It's not just in South Africa where taxpayers want dispute assessments and now we need to decide what should the Revenue Authority do or not do. So before I talk about what happens in other jurisdictions, I thought it's also a good point for me to talk about the opportunities that I've had with research, because I've been privileged to see quite a lot of jurisdictions, and I've had amazing opportunities. I mean, I would never have expected that I would be presenting on Pay No Argue later at the European Commission. So I want to acknowledge, because of course this does not come for free, I want to acknowledge Professor Franson, who was my co-supervisor for my doctorate. He's Saatchi Chair that also provided me with funding when I was a doctoral student. I want to acknowledge the NRF, my own research funds, the faculty, the school rink, and then also sometimes Prof. Legwala's rink. So I want to acknowledge all of these opportunities that I have had in my career. And then, of course, all the amazing colleagues that I have met throughout all of these travels. And the travels doesn't need to be far. I'm looking at Professor Annette Gutu, where I would go to the University of Pretoria, and that's always a great opportunity. And now I know, now that I've put the focus on Annette, she wants me to say something about international tax, right? So let the record show that I said the words international tax in my inaugural lecture, Annette. So, but we are talking about what happens internationally with the Pay No Argue later rule. So in Canada, they have this principle of the collection commencement day. So collection commencement day means as soon as the taxpayer, and I'm going to make it in South African terms, as soon as the taxpayer gets the assessment, for 90 days, the Revenue Authority is not doing anything. In those 90 days, the taxpayer can then decide, am I going to object to this assessment or am I going to make a plan to pay this? If the taxpayer objects, then that commencement is delayed even further. It is only once the Canadian tax court adjudicates this matter, so decides in favor of the Revenue Authority, that the Revenue Authority will then continue with the collection. So, I mean, if you think about access to courts, that is pretty good. Because at that stage, the tax court is impartial forum who has listened to this and has adjudicated the matter. It's not just simply the Revenue Authority deciding this. The taxpayer has had the opportunity to state its case. Of course, here, I want to just pause and say, I know we are not Canada. I realize that we are not in the same position where we can just delay the payment obligation, and I'll get to that maybe towards the end. They do have certain exceptions in Canada. So when they don't just delay the payment up until the tax court has decided this. So the first one is if it relates to withholding tax. So this is, for instance, you have your employer who's withholding, so like vets withholding portions of a salary and paying it over. For that, they would not wait to collect that. They would collect it immediately from vets. Or large corporations. So when we deal with large corporations, in Canada, that's where there's a taxable capital of more than 10 million Canadian dollars. So in those instances, that specific corporation would need to pay 50%. The rest would then be suspended up until the matter has been adjudicated. Of course, there has been criticisms where the corporation says it has a major impact on their cash flow. And I know it might look attractive to us to say, let the big corporates, let them pay. But we also need to recognize the big corporates also have employees that they need to pay. And I think in those instances, the matter of non-dambula is really important. So it doesn't deal with the Pay No Argue later rule directly, but the court there says that we need to recognize the impact that tax collection can have, not just on the taxpayer, but also all the other ones. So there is a ripple effect that we have in relation to dealing with collections. Then, of course, there's also another exception, and this is where the Revenue Authority is of the opinion that it would be in jeopardy. The collection of the taxes would be in jeopardy if we delay the payment. But then they would give 72 hours notice to the taxpayer, And the taxpayer can take this decision on review to show there's no jeopardy, the money will be here if we collect towards the end as we proceed with the dispute. And then lastly, which is very interesting in Canada, even though the payment obligation is suspended, quite a lot of taxpayers do pay. And it is because interest continues to run. In all instances, interest will continue to run. So they recognize, let's rather pay and avoid the interest that is occurring in that instance. And then later at the end, the Revenue Authority can pay that back with interest. But then the most interesting and what I really like about Canada is that they have this, that when the tax case is adjudicated right at the end, the judge has the jurisdiction or the discretion to say that this entire process was frivolous and vexatious. It was just simply because you wanted to delay the payment. And then the court can impose a penalty on the taxpayer. So the taxpayer is not able to just go about and have their payment obligation suspended when they don't have a strong merits in the case. Then if we look at Australia. So Australia has the discretion to recover. So it's not a must. They can decide whether or not they want to collect or not. And then in instances where they've decided not to collect, it's when there's a genuine dispute. And I think on a surface level that makes sense, where you can say, oh, it's a genuine dispute. But of course that means that the Revenue Authority would need to go into the merits, because how else would they know whether it's a genuine dispute or not? And of course, then that mixes up what we kind of see about the principles where we see the payment obligation is kept separate from the merits. So that is a bit confusing because you would only know if it's a genuine dispute if the matter has been finalized. And then Australia also has, in certain instances where they do not recover the tax pending dispute resolution, is the 50-50 agreement. So they reach an agreement with the taxpayer to say, you pay 50% and 50% is suspended. Of course, this is great if you think about the interest, because then you are curbing the interest. It's only 50% that will continue to run, but of course you're also losing 50% of money that you could maybe have used in your business in the meantime. The 50-50 agreement, something that is not incredibly great about it is, of course, the fact that it's not in legislation. So it's completely up to the discretion of the Australian Revenue Authority. And I think in South Africa, I feel like we want everything in legislation. We want to know when will it be decided, how will it be decided. I don't know if it's just the time we're in at the moment, but we want to make sure what is the discretion and how is it going to be exercised. And then the last jurisdiction that I want to look at is Nigeria. So Nigeria does suspend the payment obligation right up until the end, so until the last decision has been made and you can't dispute it any further. And I think it's here very much, again, about context. Nigeria in the past has not been as reliant on taxes because they have crude oil. It's not the same as South Africa where we have a small tax base and we need to make sure that those monies are collected as quickly as possible. So they do suspend it, which sounds amazing for taxpayers' rights. But then when you go into the detail of how the Nigerian system works, if the matter is heard by the Tax Appeal Tribunal, the Federal Inland Revenue Service can indicate or they can prove, so they need to satisfy the judge that this dispute resolution is actually frivolous and vexatious. It's only for them to show the evidence. The taxpayer is not a party in showing or disproving this. And if the court is satisfied that it's frivolous and vexatious, then the taxpayer has to pay a certain portion before they can continue with dispute resolution. So this is very different from what we spoke about earlier. What we now have is you have to pay, otherwise there's no access to courts later on. So this will definitely not be something that we can have in South Africa. It massively infringes on the right to access to courts. And we've seen in some other jurisdiction, in Italy and Spain, it's been held to be unconstitutional. In Uganda, where it was initially that you have to pay 30% before you can dispute, it was held to be unconstitutional. And one judge indicated that it's similar to a boxing match, where the one opponent's hand is at his back. And that is what happens to the taxpayer if they have to pay a portion in order to proceed, because tax litigation is extremely expensive. So that is what happens in other jurisdictions. And I know ideally you want me to say, so this is the ideal, this is the silver bullet that we should do for South Africa. And maybe this is the part where I'm like, so in future, I will think about this some more and how to deal with it. But I think what is important that I want you to realize when we think about the pay or argue later rule, the pay or argue later rule does not exist in isolation. As I said in the beginning, it's very much about then the enforcement powers are there. But then, of course, all of this does not exist in isolation because we, as a country, taxes should be collected. And then ideally, taxes should be used for legitimate government purposes. So there's so many things that play a role when we think about tax. And the same way as I think about all of these things, all of these underlying things, and you can never think about one thing just in isolation, I also want to acknowledge that I do not function in isolation. I am not just simply someone who relies on my colleagues and my previous colleagues and everyone to do research and to teach. So I want to acknowledge the people that really make sure that my life is not just about deadlines and tick box exercises and to-do lists. So I want to acknowledge the friends that make sure that I'm able to also do other things. So I'm looking at my hiking friends, Fran, Carmen, and Bernice. You've taken me literally to heights that I never wanted to be. But I do appreciate all of those moments. I'm thinking about my trainer, Bassi, who makes sure that I don't just struggle at work, that I also struggle in the gym quite often. Yeah, and then I also want to acknowledge the people, and it's not, so those I've mentioned, it's not to exclude you from this list, please. You know, I'm so worried that I missed someone, and I already know I missed someone who I'm going to send a message to afterwards. Also to acknowledge the people that when my life does not go according to my planning and according to my to-do lists, those who are there for me. So I would like to acknowledge my friends. So those that I've mentioned already, you're also included. But specifically, Professor Corlia van Heerden, Professor Jacqueline Barnard, Professor, now I need to think of all your surnames, Professor Hermie Kutsie, Professor Trinell Joubert, Professor Richard Brits, and Professor Melanie Roostop. So I do appreciate, and even though I've left the University of Pretoria, I know that we will always be very close friends, and I do appreciate you. And then, of course, I started out talking about when I did my master's. But I didn't just wake up one day and I was doing my master's. I came from somewhere. And I want to acknowledge my family that's here tonight. You know, they've seen me when I'm too hot, when I'm too hungry, and when I'm just being a typical middle child. So I want to thank you for my family. And then, you know, the thing about family is they always keep you humble. I will never remember the day my nephew said to me, Tannie Krieks, jy weet nie alles nie. So I do not know everything. Him and his dad, they do know everything. So I'm fortunate to have that in my life. So I want to say thank you to my family. And then also want to say thank you to my parents. So I think I've had the most amazing upbringing, the most amazing household. It was never about achievements. It was always about, have you done your best? And are you happy? And I want to say thank you in my dad's absence, and then to my mom. Thank you so much for giving me the upbringing that I have. You know, so recent times, my mom has become my traveling partner. And I've just realized, you know, you do come from somewhere where this pliggigness that I have in me, it comes from my mom, very much. And I don't know if I should thank her or what I should do with that, but I acknowledge it comes from my mom. And also this always keeping at it and studying. I was at varsity when my mom got her accounting degree. And I remember her waking up at 4 a.m. every day. So I couldn't do the same with my accounting degree. I had to wake up at 5 a.m. I'm just not as diligent as my mom. And then, of course, my dad. So I always hear him in my mind saying how education, no one can ever take it away from you. So whenever the question is, should you go for something in education, the answer is always yes. And I'm not sure, I think by now he feels like, okay, Carika, that's enough. But I want to acknowledge my dad in that. And then, of course, lastly, I want to thank my Heavenly Father for my parents, for my family, for my friends that's there when things do not go according to my to-do list, for my colleagues that's there to support me, for all the opportunities that I've had. I'm truly blessed at this stage in my life, so thank you.
Please continue the applause for Professor Keulder. What a wonderful and witty journey through your work, sharing with us what inspired your research focus, talking to positive developments so far in tax law, your thoughts on what's needed as we balance taxpayer rights and obligations, even if you haven't yet found the silver bullet. And we've all learned a new term, the Clinic Macy. But let me say what a wonderful and lovely nod you've also given to your mentors and your collaborators and your co-authors and the role that they've played in your journey, and I'm sure they're all beaming with pride. We're also pleased to have with us this evening Professor Thabo Legwaila to share some of his thoughts on Professor Keulder's lecture and her academic trajectory. Professor Legwaila holds a bachelor's in law from the University of Venda, an LLB from Wits, an LLM from Wits, a PG tax law from UCT, LLM from UCT, and LLD from Pretoria. So that's 1, 2, 3, 4. In his career, Professor Legwaila held various positions, including lecturer and senior lecturer at the University of Stellenbosch, research fellow at the Harvard University International Tax Program, senior tax consultant at KPMG and EY, director of business tax at the South African National Treasury, extraordinary lecturer at the University of Pretoria, head of tax for the Africa division at Citibank, professor of tax law at the University of Johannesburg, member of the Davis Tax Committee, chief executive officer of the Office of the Tax Ombud, and now a professor in the School of Law at the University of the Witwatersrand. Professor Legwaila, thank you for joining us. Please do come to the podium.
Thank you very much, Professor Cohen, and good evening, everybody. Good evening, everyone. You know, when I was sitting there, I thought there weren't as many people behind me. So now I'm standing here, I'm trying to figure out how am I going to address all of you. And officially, I'm supposed to give a vote of thanks, right, Prof. Cohen? But I think that Prof. Keulder thanked everybody in her speech, and very important speech. I think that one of the things that I would like to do is to just remind you a little bit of Carika. There are certain things that have not been said about her. I liked when Prof. Cohen spoke about the fact that she actually has a BCom in International Accounting from the University of Johannesburg with distinction. I just like to mention that she got this degree this year after she finished her doctorate a long time ago. I think that's a beautiful achievement there, Carika. So she has restarted school again. You know. I must also mention that with a lot of envy, we watched her as she got an award in our school, in our faculty, as our faculty is Commerce, Law and Management, as the individual or the award for individual teaching excellence for 2024, which she got this year. Which basically means that she's the best lecturer here in our school. Now, Carika focuses on tax administration. Tax administration is a very important aspect of the tax system. Think about SARS. SARS is the tax administrator. Now, she researches in that area. And tax administration covers the administration of all taxes that there are in the country, with a few exceptions. Now, some of us are experts in certain areas. Professor Van Zyl is an expert in indirect taxes, VAT included. And by the way, Fanny, to the extent that you disagree with me on the pay now, argue later, just keep it to indirect tax and leave tax administration. For example, Professor Annette Ogutu, that Carika spoke about already, is an expert in international tax, undisputed. And she focuses on that. She never ventures into tax administration because of the complexities thereof. I would say that Professor Lizelle Trudeau is a corporate tax expert who does not venture into tax administration as well. But then for Carika, she needs to have a good functional understanding of all of these systems in order to see how they are administered. And I think that is a big achievement, and that is a very good area of expertise. I must say that ever since 2011, when the Tax Administration Act was enacted, Carika did a lot of research that actually adds a lot of value, a lot of scholarship into tax administration and its understanding. A lot of her work is used not only in academia, but it's also relied on by a lot of people in the tax world, lawyers, accountants, and the like. And that is the importance of her work, and that is the effort that she puts in there. So she talks about a tax system, tax administration, where we're collecting about 2.3 trillion rand a year in the country. And through the system of tax administration, in the previous year, we ensured that we refund up about 8.8 billion to leave us with the net revenue of 1.6 trillion, right? That's in the tax system. We've got wasteful, fruitless, and corrupt expenditure of, let me not stress you, we've got a good day today. Now, part of a good tax system, Carika, is, and good tax administration and good research in tax administration, does not go only up to the technical workings of tax administration. And I hear you more and more talk about how tax administration can be improved to have positive impact on things like our national development goals and the plans. And I think that that is the growth in your research. That the tax system, you should not do, your research should not end with just collection. It needs to look at the credibility of the tax system and how it relates with taxpayers. It needs to go into issues of tax morality, how taxpayers feel. We need to ensure that our tax system is not draconian. You touched on aspects of tax administration and how much powers the SARS has in relation to tax administration and collection. Some of it is necessary. Most of it is necessary. All of it is necessary. The issue is how it is applied and how the tax authority uses it. We've got about 6 million taxpayers, income taxpayers in the country. I've heard people defending government and defending the tax administration and saying, no, we've got more taxpayers than that because VAT is a tax, and therefore everybody who pays VAT is a taxpayer. And I think that is the most crude way of trying to defend our government, where you basically are acknowledging that the tax system is dysfunctional because you therefore are saying people that are exempt or that are exempted from paying income tax or that are not yet at the threshold of paying income tax have to pay VAT. So you don't tax them here, but you tax them there, and then you say that our tax system is fair. I think that is just a very, it's the poorest way of defending where we are as a country. But what I would say to you is that a tax system and the tax administration has to be designed in such a way that it improves our situation. A tax administration needs to look at the fact that we broaden the tax base. It needs to look at the fact that we bring to book those people that commit all sorts of illegal activities in the country. I know it's not the responsibility of the tax system, but a tax system needs to function in an environment where people are held responsible. And we've got a problem of the bucket, where we've got a leaking bucket. We collect more and more every year. We spend more and more on what we should not be spending on. And that puts a pressure on the tax administration. It puts pressure on Carika and other tax administration experts. Are there any? Other tax administration experts to ensure that our tax system is improved and it collects as much as it could. I'm just saying that we need to broaden that. Prof. Jason, the problem with being called to reply to a speech is that you need to think about it as she is talking about it, because you couldn't have prepared more. But I would say that right at the moment we are at a position where our tax laws over the previous years have changed quite a lot, but to a very large extent they changed in order to ensure that there is more revenue collection. We have detached ourselves from tax policy and making sure that our tax policy is good. And it's research like Carika's that actually would help us improve as a country, because when she does comparative analysis, she looks at what other countries are doing, and that actually helps us embellish the tax policy of our country. I'd like to not bore everybody here, especially Carika's family, about the tax and the tax technicalities of the tax. The group that agrees or disagrees with the pay now, argue later, we can have a gathering afterwards. But I would like to congratulate your family, Carika. I would like to congratulate the family. I mean, like, obviously, you saw her when she was young. You raised her to the great woman that she is, and she makes a huge impact to most of our lives and our careers and our professional lives. She spoke a little bit about deadlines. I always get happy when she gets upset with Fanny because of the deadlines, because I'm not the worst person at that point. I'd like to congratulate the school and the faculty for having somebody like Carika in our midst, and encouraging her and growing her. But finally, also, before I congratulate myself, I'd like to congratulate you, Carika. Carika and I come from far. As she spoke a little bit about how we met and how we worked together. But I would like to congratulate you quite a lot. I think that you deserve this promotion or this role more than you can imagine. You've deserved it for a long time. I can tell the people about how you applied for it, or I can decide not to say anything. But I must say that Carika always doubts herself when it comes to moving on. Carika would always want to make sure that she ticks all the boxes, all the T's and the I's are done, whatever needs to be done to them, and before she could actually make a move. And it was quite an interesting interesting conversations that we had, me and her, before we got here. And congratulations on that. It was very well deserved and due. Carika works with extreme etiquette. Extreme etiquette. In terms of time, once again, she is very thorough. She is that person that will read that manuscript 5 times and still change it. Until she can't change anything, it's not going anywhere. And I think that is what soars you to new heights all the time. She is very willing to learn. She's very technical, yet fun to work with. By saying fun, I don't exclude that it can be very emotional at times. And she did promise me that today she's not going to cry, and congratulations, well done on that as well. Ladies and gentlemen, thank you very much, and thank you very much for allowing me to be here with you as well and replying to this, and thank you everybody for being here with us. I hope, Prof. Cohen, that there is some wine after this, and if there isn't, we look at him with bad eyes. Thank you very much.
Please, another round of applause for Professor Keulder. And thank you, Professor Lekhwala. Friends, this brings us to the close of our proceedings. Thank you all so much for joining us. Thank you to Carika's family and friends who've been here to support, and to colleagues who've joined online from across the university and from the school. Thanks for coming. And thanks to our functions and events team for their organization and ensuring that this event ran smoothly tonight. I also hope there's wine, but I'm not sure. But I do welcome you all to join us for some refreshments outside in the foyer and a chance to catch up with Carika and to congratulate her. I'll ask the Deputy Vice-Chancellor, the Head of School, and Professors Carika Keulder and Lekhwala to lead us out in the procession, and we'll meet you outside afterwards.